And welcome back to more Talking Law TV. I'm Michael Short, and we're here with Christie Register. Christie's back to answer viewer mail questions.
Yes.
So, you ready for
Ready.
them? Okay, this is from Laura in Pooler. I've lived in my apartment for 8 months. I've just been informed when my lease is up in 60 days. My rent's going to go up $200 a month. My question is, can I leave before my lease is up? I found other apartments for a lot less if I take them now.
Nah, short answer, no. She's going to have to finish out her lease unless she can work something out with the landlord. You know, a lot of times you can say, I'd like to get out earlier. Will you start advertising and see if you can get it occupied, and they'll agree. But if not, just because, you know, the landlord was pretty much just being courteous, letting her know that when you renew the lease, the rent is going to go up. But her current lease remains as is, and she'll have to complete that or pay the penalty for leaving early.
So she has a better chance of getting the other guy to hold the apartment, which is probably not going to happen either.
True. But, you know, people are constantly moving, getting evicted, so there are, you know, apartments coming up frequently.
Okay. Next one's from Ronnie in Egypt, Georgia. Who wants to know if his company can make him work 7 days a week. Being from Egypt, there's a history of that.
Yeah,
anyway.
right. You know, Georgia is an employment at will state, which generally means your employer can fire you anytime he wants to. You can quit anytime you want to. So if your employer needs you to do something, the answer, in my opinion, would be to do it. Can he force you to do it? No, he can't force you to come to work. But if you want to keep your job, then you're going to have to do what needs to be done. Obviously, in a case like that, if it becomes a routine and it's more than you can handle, try to find another job. But often, if you have an employer that has a need and you don't fulfill it, you're going to find yourself without a job.
Okay. Hope that helps, Ronnie. Our next question is from Paul.
One more thing. This employee, though, would be entitled to receive overtime pay.
That's a state law?
Yeah, over 40 hours, yes. They have to pay you overtime.
Is there time and a half or double time or anything like that?
I want to think it's time and a half, but don't quote me on that. I know that they can't expect you to work those extra 2 days and not pay you, so you definitely would get paid for that.
And in this economy, you know, working every day is better than never.
True. I know. I'll hear people talking and they're like, oh, I hate my job, I'm going to quit. I'm like, get you another job in place before you quit, because the job market is still not good.
Okay. Our next question is from Thunderbolt. It's Paul, who says he has a 12-year-old stepdaughter he'd like to adopt. He's been married to her mother since the child was 2. Her biological father doesn't see her on a regular basis, but he still pays court-ordered child support. Is it legal for me to adopt her, and what's the process?
He would be able to adopt her if both the mother and the father consented. With the father continuing to pay support, though, he couldn't adopt her without either the cooperation of the father or having his parental rights stripped, which is very difficult to do, especially with a parent who's supporting the child financially.
Now, if in the event that he did adopt her, would the biological father's responsibility to pay child support be over?
Yes. You know, you can't have 2 fathers, so not legally. So yes, once an adoption takes place, the rights and responsibilities of the biological father or her father would cease. So you got to think about that. And, you know, a lot of people say, well, you may have a situation where we'll just stick with fathers to keep it simple. The father passed away and my current husband wants to adopt the children. Well, yeah, you can do that, but often doing something like that will terminate support payments. So if your children are getting survivor's benefits and they get adopted, those benefits could stop. So that is something to think about. And another thing, too, is that, you know, if you get adopted by one parent and the rights of the other parent are terminated or cease, then the rights of the child to that parent cease. So you're no longer an heir. So, you know, it's more than just a quick adoption. I want to change my name so his name will match mine. It's a lifetime. You are no longer an heir to this person. So it's a lot to think about.
Okay. Our next question is from Helen on the south side. Her ex-husband was awarded possession of their Harley Davidson. It states in their divorce papers he would be responsible for the loan secured by the Harley, and that she would be free of all liability.
I'll see where this is going. But he's not paying.
He's not paying.
And what can she do?
And it's now 3 months behind, and she's not riding the bike, and apparently some other girls are riding the bike with him.
No. Can make matters worse. You can divorce your spouse, but you can't divorce your creditors. So in that case where they are both on that note to the Harley, but only one party gets to keep it, it is often a mess. The only thing she can do to satisfy that obligation to Harley Davidson is either pay the note or pay it off. You know, ideally, in a situation like that, if one party is going to keep the vehicle, get it refinanced. Or just sell it and satisfy the debt, because this I can't recall all the times that I've seen people, mostly for bankruptcy matters, where one spouse, a former spouse, was supposed to pay and they didn't, and the creditor is coming after the other spouse who doesn't even have the benefit of using the vehicle, which stinks.
Okay, our next one is from Midtown. It's Franklin, who received a summons yesterday, according to the letter, regarding a credit card with an unpaid balance of $3,300. He doesn't have the money. I tried to negotiate a payment schedule, but they're not responding to me. Can I make them do that, or do I go bankrupt? What do I do?
Well, that is an unsecured debt, so bankruptcy would take care of that matter. Need to file an answer timely. And it's typically 30 days from the date that you get served that you need to have an answer filed in the court, not put in the mail, but filed. Often, once you do that, you can reach an agreement with the creditor's attorney, and what they would want to do is enter into a consent judgment, which would be a judgment that says, okay, for this $3,000 debt, you agree to pay us $100 a month starting on this date. If you don't do that, then the entire debt is due with interest, and they can put a lien on your house, they can garnish your wages. So I found that most creditors, if you will just respond to them, they'll try to resolve it and let you make payments.
Okay. Need about a 30-second answer on this one. It's from a student at a college downtown. I needed to terminate my lease. Was told by my landlord I can sublease my apartment. I advertised and found a new tenant, but now the landlord tells me he's entitled to keep my deposit.
He would be. And typically, if you're going to sublease something, you want to get a deposit from the sublessor, so the lessee. So yeah, he would. The bottom line is the landlord wants a deposit from somebody. He doesn't care if it's your money or the person who's going to be staying in the house.
So the person who takes over your house,
needs to pay a deposit.
Do they then get your deposit back when it's over, or not? They will.
Yeah, if they've paid you a deposit, then yeah. And it may be that you want to get your money back from the landlord in exchange and give the money from the new tenant.
So it's just like A for B.
Yes.
Okay, thank you so much.
Thank you.
Hope you enjoyed this episode of Talking Law TV. I'm Michael Short with our usual guests, Christie Register and Doug Anders and Gene Brooks. We hope you join us again next week right here. If you have any questions, you can call us through our toll-free number at 888-203-7LAW or through our website at talkinglawtv.com. We'll see you again next time. Bye-bye.